Introduced a new youth justice bill this afternoon. The bill would amend the Youth Criminal Justice Act. One amendment would allow judges to impose stronger sentences on young offenders found guilty of serious crimes. Rob Nicholson made the announcement just an hour ago at the Ottawa Police Headquarters.
There are cases in which judges say they would like to have made taken into consideration the deterrence and the denunciation with respect to those crimes, to send out the correct message and to bring the message home to that individual.
Let's get some reaction to all of this, and with that, let's go to the foyer of the House of Commons. That's a good place to get reaction all the time. We'll get it from Conservative MP Rob Moore. He is the Parliamentary Secretary to the Minister of Justice, and Joe Comartin, who's the NDP Justice Critic. Gentlemen, nice to see you. I'm interested, Rob Moore, I'm looking at the release, and it says deterrence and denunciation are the objectives of the bill, and I'm wondering, what does denunciation mean? Is this a public kind of denunciation that you're thinking of, or what?
That's right. We made a commitment to add to the Youth Criminal Justice Act deterrence and denunciation, and what it is, and Canadians rightly recognize that a sentencing provision that should deter young people or others from committing a crime, and denunciation is the public response to a crime committed by a young person, to show that the public do not accept youth crime, and we know that has been sorely missing in the past when dealing with the youth criminal justice system. It's resulted in a revolving door system where young people know that there's very little consequence for crime. We needed to add deterrence and denunciation in order to toughen up the sentencing provisions. Okay, but who does the denunciation, and how? And is it in the courtroom or in public, or how does it work? That's right, Don. Denunciation and deterrence as well are sentencing principles. It says that a sentence should deter someone from committing a crime again. I think we can all agree that that's a reasonable goal of sentencing. And denunciation, a sentence should also send a message that we as a society do not accept the criminal actions that have been taken. Deterrence and denunciation are not currently in the Youth Criminal Justice Act as a sentencing provision, and that can explain a bit why our Youth Criminal Justice Act has been so weak, and there's such dissatisfaction from coast to coast amongst Canadians for the way our justice system deals with young offenders. Okay, Joe Comartin, I think deterrence, people can understand deterrence and decide what they think about that. Denunciation, how do you feel about this idea of denunciation? Do you think that that's something useful to add to the youth justice program?
I actually don't. I don't have much faith in deterrence either, especially for youth. My concern, quite frankly, Don, though, is more whether it'll survive a challenge under the Charter. The Court of Appeal for Ontario, for instance, has just made it very clear in this last spring in a major decision that they expect the legislature to continue to treat youth differently than adult people who have committed crimes, so youth criminals versus adult criminals, to be treated differently, with the emphasis on in youth crime, when convicted, on being rehabilitation, reinstating them into society as viable citizens. That's where all the emphasis has to be. I'm quite concerned as to whether that part of the amendment that's being proposed is going to survive a challenge. It's actually working its way up in another area in front of the Supreme Court. We probably will get a ruling on that in the next 6 months or so. But it's a real problem, and I think this section is going down a route. Denunciation doesn't work. We know that from any number of studies done around the globe, especially in a society such as ours. And deterrence, other than very limited circumstances, doesn't work. So talk about general deterrence as they are in this section. It's not a principle that's viable in terms of solving the problems we have with youth crime. I mean, if they really wanted to do something, they wouldn't be spending their time on this. They would be looking at prevention, would be putting more police officers in the street, and would be putting programs into place that would be dealing with youth crime.
And Rob, just to go back to the point Joe made a moment ago, in this, rehabilitation is not seen as a useful way to proceed, so deterring people from getting into the situation in the first place by a long sentence and then by being publicly denounced. I'm still not quite sure, maybe you can help me with this, who would actually, would it be the judge who would do the denunciation? Would it be the victim? Would it be a public denouncer? Or how would this work? I don't get it.
The way it, obviously, preventing someone from committing a crime and rehabilitating young offenders is paramount. That's obviously a cornerstone of the system, and nothing in this bill changes that our goal is to have young people that are productive members of society. But we also know, and Canadians have been telling us, that they want a criminal justice system that sends the message to young people, that crime does not pay. And for example, I mean, to Mr. Comartin's assertion that deterrence does not work, young people and older people, older criminals, know that there is not a consequence for young people when they commit crimes, and that's why they have been bringing young people into the criminal system and using young people to commit criminal acts. So we know that deterrence does work as a sentencing principle, and we have to add that to the youth criminal justice system. What it means is that a judge, when making a sentence, has to consider deterring young people from committing future acts, deterring that individual from committing future acts, and also denunciation of the act.
Well, I can see that it might deter that person, but particularly if they're still in jail. But Joe, pick up on that. This has to be the last word.
If he's talking about deterrence of people luring youth into crime, the criminal code already deals with that as an adult crime for those adults who are doing that. We know it simply doesn't work. Deterrence does not work. You're dealing with youth who, for all sorts of reasons, health problems, drug addiction, alcohol addiction, are committing serious crimes. And we recognize that, but you cannot deter that by simply imposing harsher penalties.
Okay.
It doesn't work.
Got to thank you both. Joe Comartin, Rob Moore.
Thank you.
Thanks, Don.
We've